stopped her for expired tags, and she pulled into Mount Carmel, and I was like, there's something off. I'm gonna sit and see if she dipped out on me. So I sit there and wait. Pulls back out. She sees me behind her. She does an improper turn in the middle of Cleveland Avenue to go north. I was like, I'm gonna light her up. Put in park.
Huh?
Because I put in park.
Sure.
The reason I'm stopping, your plates are expired. What's all this crazy driving you're doing?
Yeah, I'd like to talk to my lawyer.
Hey, Cleveland and Polaris, King Frank Paul, 4943, KFP 4943, on a blue Ford SUV.
Cleveland, Polaris.
Put in park.
Huh?
Because I put in park.
Sure.
The reason I'm stopping, your plates are expired. What's all this crazy driving you're doing?
No crazy driving.
That improper turn in the middle of the road, dipping into Mount Carmel. Where are you coming from?
No, I don't. I'm going home.
I said, where are you coming from?
A friend's house.
Where at?
Carmel.
Where?
Like around here.
Around here where?
Barely.
Around here where? Barely's not an answer.
Bernard's.
What?
Have you ever heard of Bernard's?
Yes. How much have you had to drink tonight?
Nothing.
Nothing at all. So I step you out and check your eyes and give you a test.
Sure.
Okay, go on and step out for me. You got any weapons or drugs in you or anything?
No.
All right, go on and step out.
On the 3rd of February, 2025, an Ohio officer initiated a traffic stop on Cleveland Avenue. 2 independent violations justified the stop expired registration plates and an improper turn in a public roadway. Under Terry v. Ohio, those facts establish reasonable, articulable suspicion. The stop was constitutionally sound.
Go ahead and step out.
Yeah, I'd like to talk to my lawyer.
Go ahead and step out.
Mm-mm.
Okay, look, you can step out. We can do this the easy way or we can do the hard way.
The hard way.
You're getting out of the car. You're not about to pull you out of the car, right?
No, absolutely not.
Yes.
No.
All right, take your seatbelt off.
Honey,
Take your seatbelt off.
that's not appropriate. What?
Get out of the car.
That's not appropriate.
Get out of the
Oh,
fucking car.
that's not appropriate. Oh, that's not appropriate.
Stand up.
Yep, you can search me and you won't find any weapons. You won't be able to search me. Thank you. Yeah, there's no reason to search me. Am I being detained? Am I being detained, officer?
I'll talk to you in a second. One, when I tell you to get out of the car, you get out of the car. You understand that?
For sure. Am I being detained?
Walk back here.
Am I being detained? Am I being detained?
Look, I can smell the alcohol coming off your breath. So how much you had to drink tonight?
Nothing. Am I being detained?
Can I check your eyes? You can let me check
No.
your eyes?
Am I being detained?
You're under arrest now.
Am I being detained?
You're under arrest, like I just told you.
I'd like to speak to a lawyer.
All right, I'm gonna read you your rights, okay? You're gonna listen to me? All right, before you answer
Sure.
questions, you understand your rights. You have the right to remain silent. Anything you say can be used against you in court. Right to a talk lawyer before you answer questions and have a lawyer present during questioning. If you cannot afford a lawyer, one to be appointed to before any questioning if you wish. If you decide to answer any question now, a lawyer present, you still have the right to stop answering any time. You also have the right to stop answering any time until you talk to a lawyer. Do you understand? Do you understand? Do you have anything on you we need to know about? Any drugs or anything?
I'd like to speak to a lawyer. Your pat down was not confidential.
My pat down wasn't confidential? Okay. You can have a seat in the back of my car. I'll check her pockets before I put her in.
Am I being detained?
You're under arrest.
Am I being detained?
Detained is
Why are-
less than being under arrest. Under arrest, you're
Am I
nar-
being detained?
You're
No,
under
you're
arrest. Why are your pants all undone?
When the subject refused to exit the vehicle, the officer invoked his authority under Pennsylvania v. Mimms. That 1977 Supreme Court ruling holds that an officer may order a driver out of a lawfully stopped vehicle as a matter of course. No additional justification required. Compliance is mandatory. At 58 seconds into the stop, the subject said, and this is the critical phrase I'd like to talk to my lawyer. Under Edwards v. Arizona, once a suspect clearly invokes the right to counsel, all custodial interrogation must cease immediately. That right does not require waiting. It does not require a second request. One clear invocation is sufficient. However, at this moment in the stop, formal arrest had not yet occurred. The Sixth Amendment right to counsel had not yet attached. Under Kirby v. Illinois, that right attaches only upon initiation of formal criminal proceedings, not during a roadside stop. The Fifth Amendment protection against compelled self-incrimination, however, applies during any custodial interrogation, and once the officer's exit order crossed into the functional equivalent of arrest, that protection became active. The officer reported detecting the odor of alcohol on the subject's breath. That observation, combined with evasive answers, an improper turn executed upon spotting the patrol car, and the subject's refusal to cooperate, provided the officer with probable cause to arrest for operating a vehicle under the influence under Ohio Revised Code Section 4511.19. Miranda rights were read in full covering silence, use of statements, right to counsel, and appointed counsel. The advisement was complete and compliant with Miranda versus Arizona.
Spell it. So, initially I was going to stop her for expired tags, and she pulled into Mount Carmel, and I was like, there's something off. I'm going to sit and see if she's dipped out on me. So I sit there and wait. Pulls back out. She sees me behind her. She does an improper turn in the middle of Cleveland Avenue to go north. And I was like, I'm going to light her up. She swerves all the way over here, keeps on slow rolling, and then stops. So I'm talking to her, didn't answer any questions, weird answers, and I was like, okay, we're going to step out of the car. No, I'm not getting out. So we can do this the easy way or the hard way. You're getting out of the car. She said the hard way.
Okay. All right. Do you have any questions?
I'd like to speak to a lawyer
Okay.
before I ask questions. Yeah.
Okay. Yeah, I'm not asking you any questions, so I should see if you had
Yeah,
anything.
who are you talking to? The door?
Just talking to you.
Oh, the back door? The wet window?
What are you talking about?
I'm sorry, who were you talking to?
Okay.
All right, go step out here. Sarah, come on. It is what it is at this point. You're under arrest. Let's get through this process and be done with it. Come on, get out. Sarah, I'm asking you one more time to get out.
I'm gonna ask for a lawyer.
You can have one when you go to
We're not
court.
asking you anything incriminating. We need you to cooperate. We'll just just leave her in the car, start doing the paperwork, get her down to county.
All right, so I'm gonna read this paperwork real quick. The BV 2255. It's about providing a chemical sample. I'm gonna go ahead and read it to you. You can decide if you want to provide a sample or not. All right?
I deny.
I know. I'm still going to read it to you, and you can deny, okay? All right. You're now under arrest for operating a vehicle under the influence of alcohol, drug, or combination of them. Operating a vehicle under the influence of illicit controlled substance or illicit metabolite controlled substance. Operating a vehicle after underage alcohol substance or having physical control of a vehicle under the influence. If you refuse to take any chemical test required by law, your driver privilege to be suspended immediately, and you have to pay a fee to have the privileges reinstated. If you have a prior conviction of OVI or operating a vehicle under the influence of illicit controlled substance or illicit metabolite of a controlled substance under the state municipal law, in the preceding 20 years, you're not under arrest for state OVI, and if you refuse to take a chemical test, you will face increased penalties if you subsequently are convicted of state OVI.
I deny.
Do you want to provide a sample?
I deny.
Okay. All right, if not, do you have any priors for OVI? I believe that you do, okay? For refusal, no priors, your license suspended for 1 year, 1 prior 2 years, 2 priors 3 years, 3 or more priors 5 years, okay?
Thank you. I deny. I'd like to talk to a lawyer.
Okay. Sir, I'm asking you one more time to get out.
I'm gonna ask for a lawyer.
You can have a lawyer, but we're not asking you anything incriminating. We need you to cooperate. We'll just leave her in the car, start doing the paperwork, get her down to county. No phone calls, no nothing. And invoke her right down to Delaware County Jail.
Following the arrest, the officer read the BMV 2255 form, Ohio's implied consent advisement under Revised Code Section 4511.191. That statute deems every Ohio driver to have implicitly consented to chemical testing upon a lawful OVI arrest. The subject refused, which is her legal right, but the administrative consequences are automatic. 1 year suspension for no prior OVI conviction, 2 years for 1 prior, 3 years for 2 priors, 5 years for 3 or more. Under Birchfield versus North Dakota, decided in 2016, these administrative penalties for chemical test refusal do not violate the Fourth Amendment. The refusal itself is also admissible at trial as circumstantial evidence of consciousness of guilt. The most significant legal error in this stop came when the subject again requested an attorney, and the officer responded, "You can have one when you go to court." That statement is legally incorrect. The Fifth Amendment right to counsel during custodial interrogation is immediate upon invocation, not deferred to future court proceedings. Edwards versus Arizona is unambiguous on this point. While the officer did not appear to continue substantive questioning after that statement, the mischaracterization of the law is a documented concern.
All right, if not, do you have any priors for OVI? I believe that you do, okay? For refusal, no priors, your license suspended for 1 year, 1 prior 2 years, 2 priors 3 years, 3 or more priors 5 years, okay?
Thank you. I deny. I'd like to talk to a lawyer.
Yeah, I'll bang out the citation and I'll forget about the Come on.
Do you have any jewelry on? That's fine. Not like necklaces or anything. All right, keep going. Let's go right here. No, right here. Right here. So toilet paper in there.
I'm not going in there, never mind.
Okay.
I'll keep her jacket.
No, I'll take that back.
No, you're done, go.
Oh, here.
Yes, thank you.
Yeah, I'll put that back on, thank you.
We'll put it right back in the car. We're gonna have the heat going. Are you sure you don't want another?
I like that back on, thank you. I don't feel comfortable with that.
Okay, I'll drape it over your shoulder.
No, I'd like it back on my body, please. That's too cold. Thank
Okay,
you.
well, we're gonna put it back over your body. You sure you don't wanna use another toilet?
No, I don't like to use that one, thank you.
Okay, I just wanna make sure you have your ability to do it. All right, yeah. You all done, Graysville?
That's like that.
That, I'm gonna try that, I'll leave that at home. Step back. I agree. Don't drive me up. I wouldn't argue with you there. There you go, here, I'm very
You
cool.
sent that to me. Thank
Okay.
you. I need my.
No, you're good. No, you're welcome.
Yes, sir.
She's got something on. I know, I got you took the jacket off. And everything, and then
She got some more notes come back in your charges.
I gave her conveyance warning. I'll note it in my supplement, so if we find something, she's gonna.
Excuse me?
What? What? You need me to reach over? That's fine.
The subject was charged with operating a vehicle under the influence, resisting arrest under revised code section 2921.33, driving with a suspended license, and obstructing official business under section 2921.31. At the time of this analysis, the outcome of any criminal proceedings remains unknown. The arresting officer receives a C+. The stop and the Mimms exit order were legally justified. The Miranda advisement was complete, but the statement that counsel is only available at court reflects a fundamental misunderstanding of Edwards v. Arizona, a clearly established constitutional standard that every officer is expected to know. The subject receives a B-. She exercised meaningful legal awareness, invoking counsel, refusing the chemical test lawfully, and ultimately complying with the exit order. However, her extended refusal to exit the vehicle after a lawful Mimms order provided direct exposure to a resisting arrest, charge a risk that better legal knowledge would have avoided. The department receives a B. Processing was professional, and the implied consent form was properly administered. However, if the lead officer's misstatement about counsel reflects a broader training gap that represents ongoing civil liability risk under Section 1983 of Title 42 of the United States Code. 2 lessons from this stop. First, invoking the right to counsel does not suspend a lawful Mimms exit order. A driver who refuses to exit a stopped vehicle after a lawful order faces arrest exposure regardless of what rights they assert. Second, for law enforcement, the Fifth Amendment right to counsel upon invocation is not conditional on court proceedings beginning. Officers who misstate that right, even without continuing interrogation, undermine departmental credibility and invite Section 1983 exposure. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.